Our slot's going to be dealing with full and frank disclosure, which is a phrase more bandied about than explored. So what we want to do is probe over the next 50 minutes what it requires of us as lawyers in two contexts. So the last few years, we've seen two trends that we want to take in turn. The first is an increasing degree of rigor in the commercial context, including in the UK and BVI, as to what's required of litigants seeking ex parte relief in that regard. And secondly, an increasing focus in trust cases, where the Channel Islands has led the way, of what information should be put before the court and given to other parties to those sorts of applications. So the first half is going to be dealt with by Terence Mowschenson, QC, and Bobby Friedman, and the second half by myself and Simon Atkinson. The two areas share some common features. They give rise to difficult practical issues about what's relevant and what's not, what it demands of us as lawyers beyond just saying to the court what we know is relevant, and keeping track of changing conditions and developments up to the hearing and sometimes beyond if we're still involved. But they have slightly different underlying rationales and therefore requirements. Given our desire to focus on the practical points rather than get too bogged down in the detail of the case law, combined with the desire of my co-speakers to have their faces sufficiently prominently displayed, we've taken the bold and possibly unwise approach of no slides. So what we propose to do is to send over a list of relevant cases afterwards. We're going to seek to keep our bit to 45 or 50 minutes with questions after each half, but please in the meantime, send over any questions through the Q&A function and we'll be delighted to engage with them. So with that, I'll hand it over to Terry to kick us off on the substantive part.
Well, good morning, everyone, from a very overcast London. I'm sure that in Jersey you've got a gorgeous day with blue skies. Here it's rather grim. The duty to make full and frank disclosures in ex parte applications is a trap for the unwary or over-enthusiastic applicant or legal representative. Accordingly, I thought I'd deal first with legal principles, which in turn tend to overlap on each other, and then Bobby Friedman will deal with some of the practical problems and what happens when there is a breach of the duty. And then I'll deal with a few recent cases, time permitting. The principle is often expressed in terms of a duty of disclosure, but the ultimate touchstone is whether the presentation of the application is fair in all material respects. And that's a matter stressed by Mr. Justice Popplewell, as he then was in FSD and Dos Santos. In general, in proceedings, each party has the opportunity to put his case. However, sometimes due to urgency or because of the nature of the relief required, that relief has to be granted in the absence of a party, and therefore only the applicant is before the court. And that puts a heavy burden on the applicant because the principle of audi alteram partem is being broken, and that strikes at the absolute core of one of the principles of litigation. In addition to that, in the absence of the party, there's considerable scope for error and injustice. In the context of commercial litigation, ex parte injunctive relief is a powerful weapon. A Norwich Pharmacol order or a freezing order, we all know it's a draconian remedy. And that's why you have strict rules relating to its enforcement. If you get it, if the applicant gets an order, he gains a substantial advantage, and he gets a greater advantage if he manages to keep it. If he loses it because he's tripped up on the duty of full disclosure, he suffers a substantial disadvantage. He will have lost the confidence of the court, and the defendant will have gained a considerable psychological advantage. So far as the position between Jersey and England is concerned, there doesn't seem to be any difference at all. You'll all be familiar with the decision in Goldtron Limited and Most Investments Limited, where the Deputy Bailiff, Bird, followed Mr. Justice Bingham in Ciparex Trade and quoted at some length from that case. And in the recent Jersey decision, or recent being 2016 in this case, Crociani and Crociani, the court followed what Deputy Bailiff Burt had said in Goldstone. So we can go straight to the principles. And the first principle is the requirement of full and accurate disclosure. And the duty is to make full and accurate disclosure of all material facts and to draw the court's attention to significant factual, legal, and procedural aspects of the case. And the material facts are those which it is material for the judge to know in dealing with the particular application which is being made. And the materiality is not something that's to be decided by the legal representatives or the applicant, but by the court, which puts a heavy burden on the legal representatives for the applicant, because they've got to adopt a mindset of asking themselves, what will the judge be interested in? We might have dismissed it because we think the point's rubbish, or the point isn't good, or we know it's bad, but the judge might find it very material and be interested in it and want to know about it. This is a very high duty, and it's a duty of the first importance. And of course, it's a corollary of the departure from the principle of audi alteram partem, which underlies the whole area. Because the court is indulging the applicant by departing from the principle, it imposes a very high duty on the applicant and is often extremely tough if it discovers the applicant's broken the duty. The second principle is that the applicant's under duty to make inquiries before making the application. All proper inquiries need to be made. So the applicant's cause of action has to be investigated, and the facts relied on must be fully explored. And the duty is to draw the court's attention to significant factual and legal issues, including procedural issues, as I've mentioned. The extent of the inquiries which have to be made depend on the nature of the case, including the cause of action which is being asserted, the order which is being sought, and the probable effect of the order on the defendant, which is often an issue which is overlooked. If you're going to be closing down the defendant's business, you need to make sure the judge understands that. It's not enough simply to say, well, I was giving an undertaking in damages, what does it matter? And the duty to disclose extends to matters which the applicant would have been aware of had he made reasonable inquiries. So an applicant who doesn't make reasonable inquiries and is unaware of a particular matter which he should have been aware of is treated as having failed to make full disclosure. And no amount of urgency or practical difficulty can avoid a failure to identify certain essential matters for the cause of action and the principal facts. It's one thing to turn up with documents in a bit of a mess. It's another thing to omit crucial facts, which inevitably, when they're omitted, suddenly assume a huge importance. The third principle is that the full disclosure must be linked with fair presentation. It's very important that the judge has complete confidence in the thoroughness with which the matter is being presented. So it's not sufficient to exhibit numerous documents and not take the judge to the relevant passages. And it's counsel's duty to draw the judge's attention to weaknesses in the case. So the rule here is don't let the judge rush you on a Friday afternoon. The trap is when the judge says, I've read the papers, read the skeleton, can I have a look at the form of the order? It's very important to say, hold on a minute, I've got a number of matters I want to tell you about. I was involved in Derby and Weldon, where one of the complaints from the plaintiff's counsel, who was always getting injunctions against us, was the judge handing out the injunctions, which was Mr. Justice Weinlot, often said, I've read the papers, or oh, it's that, those defendants again have another injunction. And then we would steam into court and say, you haven't been told about this, you haven't been told about that. It was never intentional. It was just the judge was in a hurry and thought he knew it all anyway. The fourth principle is there's no distinction between the litigant's duty of full disclosure of material facts and his legal representative's duty to assist the court by reference to the legal authorities or fair summary of them, and to tell the judge the weaknesses in the case so far as the law is concerned. Bobby will be addressing you on what happens if you breach that. But the court, the tendency at the moment is the courts are getting tougher and tougher on this. And I'll hand over to Bobby straight away, if I may.
Thank you very much, Terry, and good morning, everybody. Delighted to be joining you, albeit over Zoom. It isn't quite the same as being in Jersey, albeit the commute was a little bit easier this morning. Hopefully back with you next year. So picking up from where Terry left off, I'm going to be looking at some of the practical problems, and three in particular. firstly, what to do with a Norwich Pharmacal application. Secondly, what about cases of short notice? Thirdly, looking at how long the duty of full and frank lasts. And then I'll go on to look at when an injunction may be discharged for breach before handing back to Terry, who's going to apply that by looking at some of the cases. So starting with Norwich Pharmacals, do you have a duty of full and frank disclosure at all? Well, there are, of course, scenarios in which the application will be truly ex parte, in that neither the ultimate wrongdoer, the intended defendant, or the third party from whom you're seeking the documents are put on notice. And so obviously, as you'll know, that's often used in cases where there's a risk of tipping off if the third party knows in advance. So clearly that is a truly ex parte hearing and you have to give full and frank disclosure. What about when you have a third party who is on notice, but the proposed defendant, the ultimate wrongdoer, is not on notice? And of course, it's a very common scenario if you're going after a bank, for example, that party may in fact remain neutral. And in any event, they may not get stuck in or be able to get stuck in the way that the defendant could. And of course, it's the defendant's confidential information which is being given away. So the starting point, if we go all the way back to effectively the basic statement of why you need full and frank disclosure in the case of the Crown and Kensington Income Tax Commissioners ex parte de Polignac, a 1917 case. What the court says there is it's perfectly well settled that when you make an ex parte application, you're under an obligation to make the fullest possible disclosure of all material facts. But what the court said there was that an ex parte application is one when it's made in the absence of the person who will be affected by that which the court is asked to do. So if that's the test, the person who will be affected, well, you can easily see why the wrongdoer, the proposed defendant, is the person who will be affected. Now, surprisingly, this hasn't really been the subject of proper consideration in the cases, though it has been mentioned in one more recent case, which is a case between the rather unfortunate but deliberately named claimant of Ben Dover Productions against Telefonica UK Limited. So a Norwich Pharmacal was sought in that case against Telefonica trading as O2 for the names and addresses of customers who were apparently committing copyright infringements through peer-to-peer file sharing of pornographic material. Now, for obvious reasons, you might imagine that those customers might have had a thing or two to say about whether their names should be made public for these purposes. And the argument was taken at the first hearing that full and frank disclosure had not been given. So the judge didn't decide the point, though he did say that it was ingenious. In some ways, as I go on to explain, given that I think you should give full and frank disclosure generally, it's interesting that he said it was ingenious, suggesting that it was not normal. But the judge said there that there didn't need to be full and frank disclosure, but that was for two specific reasons. The first was that a consumer interest group had intervened, and so there was full adversarial argument on the point. So what the court said there was that if you hear all the arguments, if there is someone who has skin in the game, then you don't need to give full and frank. But the second reason was that this was the first hearing, and in general, the arguments on full and frank should be brought when you seek discharge. So in other words, if one of the consumers had sought to discharge the Norwich Pharmacal order, then that was the moment to raise that question. So where does this leave us? Well, from my experience and in my view, you generally should give full and frank disclosure, assuming that the intended defendant isn't there. It is they who have the skin in the game, whose confidential information is being given away. There may be an exception if there is somebody else there who is taking all the arguments and can take all the arguments from on their behalf. But I think it would be the wrong approach and a very dangerous approach not to give full and frank disclosure if you say, well, the bank is here and the bank is on notice. So in my view, the better approach to Norwich Pharmacal applications is to give full and frank disclosure, assuming that the intended defendant, the wrongdoer, isn't there. What about short notice? Well, could you say because there is someone else there, there's opposing counsel there, that you don't need to give full and frank disclosure? Well, the short answer is that the duty is exactly the same. There's a case called CEF Holdings Limited and Mundy, and in that case it was argued that because the defendants were represented at short notice, that the duty was cut down. The judge suggested that there was a slight reduction in the duty, which was that where your opponent has already made the point, you don't need to make it again, which doesn't really add much in my view. Of course, there's no point in having to physically repeat a point that has been taken. But otherwise, the duty is exactly the same. And so that is a bit of a danger with having someone there on short notice, which is that they can make the points that they want, but then there is still entitled to require the applicant to make any points that they don't. And so you can have a scenario where someone's been on notice for 2.5 days, they're clearly represented by a very experienced counsel and solicitor team, and they miss a point. Well, you nonetheless are still required to step in and make sure that the court is apprised of that point. So the purpose behind this, of course, is to ensure that people do turn up on short notice and they don't get penalised for trying to turn up and helping the court. But it is a bit of a trap for you as applicant. On the other hand, if you are a respondent, you get it on short notice, you don't have much to lose by turning up and making such points as you can, because of course, if there's another argument that you haven't spotted, whether that's because you haven't had enough time or because you're not on the ball that day, nonetheless, you can use that against the other side at the discharge hearing. So when does the duty come to an end? Well, there was a recent Jersey case on this, Tirani and Tirani, and that case arose where there was an application for discharge or variation of a freezing injunction where there'd been a payment of a sum into court. Now that injunction had been obtained in support of English proceedings for enforcement of Bahraini judgment, and also to set aside a transfer under the English Insolvency Act, section 423. Now, what was interesting about this case was that there was an attempt to rely on apparent non-disclosures where evidence arose after the original injunction had been granted, so fresh material. And what was said there by the respondent was that they relied on a case called Wilkins and Hedrick, another Jersey case. And they said that where there was any substantial and relevant change after the injunction had been issued, then that need to be brought to the attention of the issuing judge. Doesn't matter even if it was on an inter partes basis thereafter. So the court rejected that argument. It said that the full and frank disclosure obligation continues unless and until the matter becomes inter partes. They refer back to an English case, the English case of Albluewi, in reaching that conclusion. Now, of course, this only raises the question, well, when does it become an inter partes hearing? And the court, in the course of its judgment, raised the prospect of a situation where new information becomes available only to the applicant. Well, does that mean that you as applicant need to inform the court? Well, not if it has become truly inter partes. Of course, there will always be scenarios in which you as applicant know something that your opponent doesn't. But if you, just to put it into context, if you were applying on notice for an injunction, you wouldn't need to declare all of those matters at that stage. And so in the same way, merely because you happen to know something the other side doesn't, that doesn't impose a duty on you. On the other hand, the duty does not stop merely at the moment you walk out of court with your injunction in your hand. The matter isn't truly inter partes at that point. So you would need at the very least to have served the other side. And in a scenario where you have just served them and then a material point comes up, then you should also, in my view, inform the court of that. Now, it's important to bear in mind, where I said there a material point, it's not for the applicant to decide as judge for itself whether a point is material. So if something comes up and it seems like it might be of significance, the better route is to draw that to the judge's attention after the hearing. And in practice, the way I have seen it done, I think most effectively, you can email the courts and simply ask the judge to be informed of this matter, and you can explain why you think it doesn't change the need for the injunction to have been granted. But it obviously covers you for that situation. So what if you do nonetheless get things wrong, or the other side have got things wrong, and full disclosure has not been given? So again, the key cases on this are Goldtron and Turani. What the Jersey court has indicated is that there's a twofold purpose to the rule that prima facie an injunction will be discharged if it was obtained without full disclosure. Well, firstly, you want to deprive the wrongdoer of any improperly obtained advantage, but the court also wants to act as a deterrent in doing so. So it's not enough simply to say, well, this wouldn't have made any difference to the judge on the ex parte hearing, though of course it is relevant. So in circumstances where there has been that non-disclosure, whether it's sufficiently material will all depend on the interests of justice and the various factors. So a key consideration is whether or not the non-disclosure was innocent. So where there has been a deliberate non-disclosure, it will be a very rare case indeed that the court will not discharge the injunction, though of course it always looks at the interests of justice, but that will be a very difficult starting point if you have deliberately not disclosed a matter, and that's obviously why, for various reasons, why one shouldn't do that. The court will also look at the materiality. So as I say, it's not merely a question of would it have been decided differently, though that clearly is a relevant consideration. But in the round, the court looks at how important that non-disclosure was. But of course, the court does have the discretion to continue the injunction, and it will look overall at the interests of justice. And from my experience, what you often see is that the non-disclosure ground is quite often a make-weight. So yes, in cases of very egregious non-disclosures, that of course can be sufficient for the injunction to be discharged. But it very much comes down to what the judge thinks. If you have a very clear case of fraud, the judge, and you've got a freezing order, but there's been a non-disclosure, the judge is much more likely to continue that to continue that freezing order. So there's a bit of a sniff test. The interest of justice allows the judge to look at what's right in all of the circumstances. So the court has a real range of options, and it's very much on a sliding scale. If you've deliberately non-disclosed and it was very material and you don't have a great case, then quite clearly you're not going, the court's not going to allow the injunction to continue. At the other end of the scale, where it's as is much more common, an inadvertent disclosure, it's not necessarily that material, it wouldn't necessarily have changed the judge's decision at the ex parte hearing, then you're at the other end of that scale. So I'll now pass back to Terry, who, as I say, will just briefly explore some of these concepts by reference to some of the more recent cases.
Thanks, Bobby. I'm going to be quite brief because I fear we're running slightly behind. The first case I was going to refer you all to is a case called Therma, Paraskevaides and Citco Trust in the BVI Court of Appeal. In that case, Mr. Paraskevaides had died, and the control of his trading company, which was in Cyprus, was held through 4 BVI companies, really. There was a split between the widow, a daughter, and 2 of her 2 other siblings. And there were different positions as to ownership of the shares. The new administrator, without telling the widow, had caused the boards of the BVI companies to be changed and on down through the chain. He was taking over relief. Citco had originally indicated that it was the custodian of the BVI company shares, that it wouldn't be taking any steps to exercise any rights as a shareholder pending the outcome of the dispute. Rather oddly, it then proceeded to change the boards, and it acted pursuant to a request from the administrator not to tell the widow, which wasn't a particularly clever thing to do. On the 3rd of January 2018, the new administrator wrote a letter which was elliptical to the widow, and I will read it out because one can read this letter any number of different ways. Having referred to the BVI companies, he went on, because as far as I understand and has come to my attention, several different positions have been formulated on the subject, including on behalf of Mr. Micheleris, that was his previous administrator, as well as of Citco. I would kindly ask you to inform me in writing of your positions and opinions regarding this subject, and the subject was the BVI companies. That was the first of the letters. Now that letter, which the defendant, once he'd been injuncted, alleged had not been properly disclosed to Mr. Justice Adderley, who gave the injunction, and at the inter partes hearing to remove the injunction, the judge acquiesced and said it hadn't been properly presented, which were very curious because what the administrator was doing was dealing with the structure, the directorships of these companies. That letter was followed by a second letter dated the 23rd of April, which simply said, can we have a reply to our letter of January? It didn't say any more, and that wasn't referred to the judge. And a third letter, which from the administrator, raised beneficial ownership of the shares. So when the counsel appeared before the judge to seek the injunction, they didn't attach any importance to the letters, thinking that they were dealing with beneficial ownership. What they were saying was the administrator was surreptitiously taking control of these companies. On appeal, the Court of Appeal said there had been non-disclosure. The judge at first instance held it was deliberate non-disclosure and not innocent. The Court of Appeal said it was innocent, and then rather predictably reimposed all the injunctions because they could see that the administrator really was acting surreptitiously. He hadn't told them about the change in the structure, which is what the injunction was seeking to restrain. But it illustrates how careful you've got to be, because even though the letter had been, of the January letter had been referred to the judge, it hadn't been referred to in the context of the allegation that the administrator was acting surreptitiously. And that, of course, then led to two hearings. The first one, the claimant lost, and then in the appeal, it was reinstated. The next case is Rogachev and Goryianov, where the applicant was trying to restrain the sale of a market in Russia. And he was saying that this sale was also being done clandestinely without his knowledge. But unfortunately, he misled the court in a number of respects. Again, documents were hidden in the exhibits which showed that that he'd known about the sale well before the date that he was saying he'd known about it, and well before the date that the judge thought he'd first known about the sale. In addition, one of the documents, the crucial documents, was hidden in the middle of 28 exhibits. In addition, what the applicant didn't do was to investigate the way in which the market was being sold. And there was an advertisement, a public advertisement, which he failed to draw the attention of the court to months before he approached the court for the injunction. That did not go down well. In addition, in the course of a dialogue with counsel, the judge indicated that he thought the applicant had only discovered the possible sale in November. In fact, he discovered the possible sale 11 weeks before, not 5 weeks before the application. And counsel fell into the trap, because no doubt it was a quick interchange, and the judge was saying, well, he only found out about this shortly before, and the judge says, the counsel says yes. In fact, of course, it was a critical issue, and it was a ground for setting aside the injunction. In addition, the applicant hadn't given full disclosure of the negotiations between the parties to settle their dispute. And again, because of the allegation that all of this was being done clandestinely, the court set aside the orders on the grounds that the court had been misled. In the next case of Tugershoff and Orlov, an issue arose as to whether the applicant owned certain shares. And it was common ground that he'd become a public official in Russia, that meant he had to get rid of the shares. And he told the judge was told that the defendant was bound to say he'd got rid of the shares, but that there was no real evidence that he had got rid of the shares. What happened was, if he'd made proper inquiries, he would have discovered documents which he had signed getting rid of the shares. And although the judge very kindly said that hadn't been a deliberate omission, she did say he'd been reckless, and the injunction was discharged. A similar case is Les Ambassadeurs Club, where again, the court held the applicant had been somewhat reckless. There, in the course of, the defendant had defaulted on payment to a casino, and he'd actually had a bad record. He wasn't a member in good standing. He defaulted from time to time, but he always paid up in the end. And indeed, he just had a credit increase. And in the course of argument with the judge said, well, of course, this is all very odd because he's been in good standing, hasn't he, since 2015? And the answer actually was, no, he's not been in good standing. We've been dealing with him. He's been paying up eventually. But unfortunately, counsel said, yes, he agreed with the judge. He was a person in good standing. Then the evidence as to the defendant suggested he had a small connection with the jurisdiction. In fact, he was regularly in the jurisdiction. He didn't live in a pied-à-terre, as was suggested, but in a £45 million house in Carlton Terrace, albeit held through a Jersey trust, which are always the best trusts, as you'll all know. And the court wasn't addressed about the weakness of the argument regarding dissipation, because what the court was told was he'd gone to Saudi Arabia. What the court wasn't told was that he regularly went back and forwards to Saudi Arabia, and that he always had in the past paid up. The injunction was discharged. And the judge made the point that isn't rocket science. What he said was, on an inter partes hearing, you really ought to produce a transcript of what counsel for the applicant had been telling the judge on the ex parte application, because then you can pick up the full flavour. It's not enough just to rely on notes, because inevitably the note taker tends to put down those matters which he considers important, and it doesn't convey the full flavour. I'm not going to spend any time on the last decision, PJSC, Commercial Bank. We'll give you the reference if you want the list. All that is a case really is where the court was in fact told that various companies hadn't got any money, but the defendant thought it should have been told that the money simply passed through them, and the court said there'd been no misleading. It could have been done in more detail, but the truth was, when you read the judgment, which is a major decision on jurisdiction, the Court of Appeal simply wasn't interested, thought the judge couldn't possibly have been misled, and actually didn't think the additional evidence was particularly material. So that's the commercial side of things. I think I now hand it back to Jonathan.
Not quite so fast, Terry. I'm just going to pause for a second to see if there are any questions about your tales of gambling and the like. No, not at present. So yeah, let me continue. So moving to the trust side of things, I want to start with three general points. The first is how full and frank in the trust context compares to in the commercial ex parte context. And I would suggest there's a slightly different rationale there. It's that the court needs to decide whether it should insulate the trustee from suit in allowing it to take a particular step. And you can often have situations where other parties are there with an interest in arguing against the relief the trustee wants to seek. So you're not necessarily concerned with a situation where you're anticipating points that might be taken by an absent opponent. So it's different in that respect. Rather, there are 2 points that underlie full and frank in the trust context. Firstly, that the court should be appraised of the full facts if it's to be able to decide whether it should insulate the trustee from suit. And secondly, that the court is only making a decision as to whether to insulate the trustee from suit on what's put before it. So if it turns out that full and frank disclosure hasn't been given in some important respect, then the trustee may not get the insulation it seeks, because the insulation it actually gets may not protect it when the fact omitted emerges. And the role of full and frank in the trust context, in contrast to the commercial context, isn't really dealt with in the blessing tests, whether it's the Jersey Ries test or the English equivalent. The English Court of Appeal in Cotton and Cardigan gave some helpful guidance, saying it's not really an obligation, it's part of the evidential requirements, it's part of putting forward enough before the judge to give them comfort to insulate the trustee from suit. I'd suggest that's an important element, but it doesn't capture the whole of full and frank in the trust context. Obviously, if you were, for example, to keep an element of the evidence up your sleeve, you wouldn't have given full and frank, even though you'd obviously have persuaded the court to give the relief that you sought as the trustee. The second general point, what you need to give, obviously you need to give anything that is relevant to whether the relief should be granted, and that will give rise to practical questions about where one draws the line and what volume of documentation to put before the court, particularly if it's an urgent matter and the time you can get for the hearing is quite limited. one interesting point that's not really canvassed in the authorities, but again is important and has an analogue with the commercial context, is what happens if facts are overlooked, if the trustee does its best and the professional advisors do their best, but there's an important fact out there or matter out there that's not drawn to the court's attention when it could be. That point was raised but left open in the English case with the catchy name of 3 individual present professional trustees of 2 trusts and an infant prospective beneficiary of 1 trust, which is obviously an advert for using anonymisation and judgment titles in the way that you do in Jersey. And there, the court left it open, but the hint was that if you had an omission of that sort and it was serious, it could invalidate the relief sought. And that seems to me to be right. Why should beneficiaries be disadvantaged by the failure of the trustees, or heaven forbid its professional advisors, in looking into the matter carefully enough? That leads on neatly to the third general point, which is what's the effect of not giving full and frank disclosure? And again, that's received relatively little attention in the trust case law. And I'd suggest that's because you're often not in the dynamic of an absent party turning up at a return date to pick holes in a disclosure given. If there's going to be opposition to what the trustees wants to do, it's normally either going to precede the hearing or be at the hearing where the trustee is seeking the authorization in question. Again, the infant prospective beneficiary case has something to say about that. It says it's not automatic that non-disclosure leads to the trustee losing the protection it would otherwise have. It doesn't go as far as laying down a positive test that you can use to delimit where it invalidates the relief compared to where it doesn't. I would suggest that the court should generally ask what it would have done had proper disclosure been given to it, at least in a case where there's no deliberate non-disclosure. So not quite as harsh an approach as in the commercial context, because you're not in a situation where you need to seek to hold people to a particularly high standard as a deterrent because they're seeking far-reaching relief against someone who is absent, at least in a typical trust case. So with that, Simon and I want to take a number of practical situations and talk about them a little bit. So I'm going to hand over to Simon to kick us off on that.
Thank you very much, Jonathan. The first practical problem that I want to consider is one that arises not infrequently in trustee blessing applications where you have representative beneficiaries involved. And that is where the rep bens seek to change or limit their roles at the hearing at which the court is going to be considering the trustee's application. And this arises frequently in my experience because of an all too familiar situation, and that is essentially the timing and resources issues that rep bens can face. And I'm sure you'll all be familiar with this sort of dynamic. You've begun to tee up your application to court as trustees. You've identified your professional colleagues at another firm who are going to take on the role of legal advisor. You've negotiated the scope of the appointment, what side and what arguments are the rep bens going to take. They've identified a suitable person from the class, and you've agreed terms, set out clearly the scope of the role, and they start their work in anticipation of preparing everything for court. But of course, almost invariably what happens is that the appointment is later than you'd like, the court hearing is looming more quickly than you thought, there's a mass of material to get through, there's questions, supplemental questions being asked from the legal teams, and of course, inevitably, the trustees want things done as expeditiously and cost-effectively as possible. And then what happens is you get to court and the rep bens in their submissions and their skeletons of the correspondence said, well, look, in the time available, we haven't had the chance to verify independently the legal advice you've given on the scope of the trustee's powers, for example, or taken advice on the commercial implications of this proposed transaction. And accordingly, the rep bens say, well, we can't really give, we can't identify all the possible arguments against this because we're reliant on the trustee's advice. Potentially more problematically, they might even say, well, look, we haven't been able to formulate our views on matters X, Y, and Z. And what do you do as trustees in that situation? It seems to me that at that point, you have to think, you as trustees have to think back to the purpose of the application, the professional obligations of the trustees and their legal advisors to the court. And those, of course, were that the purpose was explained in the Re-S case Jonathan's referred to, and of course in England in the X and A case. And of course, on a blessing application, the purpose is to satisfy the court that the proposed course of action is lawful within the trustee's power, and the trustees can properly form the view that the transaction is for the benefit of the beneficiaries. And the purpose is to preclude the subsequent challenge for breach of trust. And so therefore the court's going to act with caution and are going to expect this full and frank disclosure from the trustees. So it seems to me that in those circumstances, it is right and proper that the trustees should point out not just the limitation to the involvement of the rep bens, but also the implications for that on the transaction. Because of course, if the court's not apprised of that, then, and the court grants blessing, then down the line, if a disgruntled beneficiary comes along and has spotted a point that nobody else did, then there is a risk, as Jonathan pointed out, that the trustees' insulation from suit may not be as bulletproof as they thought it would be. Now, of course, you then get into the question of, well, was the non-disclosure material or not? And Jonathan has identified some of the issues that the court might consider. But I think from a practical point of view, the bottom line on this first point is if there has been a purported limitation of the role by the rep bens, then that is something that the trustees should advert to, and the implications for that in terms of their application. So on that point, I'm going to hand back to Jonathan for the second practical problem.
Thanks a lot, Simon. The second practical issue is how you deal with changes in conditions or other developments between a trustee decision and putting the matter before the court, getting the matter before the court to rule on whether the step should be taken or not. What should the trustee put before the court in that situation? What do its duties require of it? And how should it act? It's obviously very commonplace for conditions to change between a decision and the matter getting to court, particularly where decisions have been taken on complex financial matters against a financial backdrop that will inevitably shift between the decision and the court date, if anything is certain that is. Again, the test doesn't really deal with that, and it raises the following interesting questions. Say you have a decision that's perfectly rational at the time you take it. There's then a development that doesn't make the original decision irrational. But what then is the test? Is there any room to look at the changed circumstances? Need the trustee put it before the court, or can it just stick with what it did the first time? And starting from first principles, the practical point is, well, it's quite important if you really at one end of the spectrum had to take into account any relevant changed circumstances. That could be quite serious. In theory, you would as a trustee have to ask yourself right up to and on the day of the hearing whether the decision should be changed. Well, the starting point I'd suggest is that the trustee decision is effectively conditional on the court approving it, or provisional until that happens. And the court will want to be comfortable that the trustees have acted properly. And part of acting properly involves revisiting decisions where any reasonable trustee would do so. But the critical practical point, it seems to me, is that whether it is reasonable not to do so gives the trustee significant latitude to decide that it's not necessary. And whether it is necessary or not will depend on a number of factors. For example, how much the development changes the facts underlying the original decision, whether there's time to retake the decision, or whether it's important to get a decision rather than risk no decision if you have to change it, whether it's the sort of decision in respects of which circumstances will inevitably shift between the decision and the court, no matter when the decision is taken. And decisions in respect of financial matters that will inevitably shift in time are a good example of that. And lastly, whether the implementation steps that will follow the decision leave flexibility to address the change in circumstances without the need in any way to revisit the main decision itself. So I'd suggest the trustee has significant latitude to decide whether to revisit, and that is a helpful practical safety valve to avoid the need to continuously look over the old decision with the impracticality that may carry with it. Just a brief word before handing back to Simon on who full and frank has to be given to in the trust context. Is it just full and frank to the court or to the parties as well? It was suggested in the infant prospective beneficiary case that it's to the beneficiaries as well. It seems to me that it's full and frank to the court that's absolutely critical, because you can't derogate from that. Full and frank to the parties is important, but that is something that can effectively be derogated from or ameliorated in situations where it's appropriate to do so. And of course, the message that the Jersey case law gives on that is that people interested in the trust should have a proper say. They should be given normally sufficient information to allow them to make properly informed representations, R, B, C, and D, and a host of other cases, because you're affecting their right to sue the trustee by the court ruling that the trustee can take the step in question. But Equally, there can be good reasons why you should not give the beneficiaries full, or in some cases, any information. And the question is often in practice how willing you should be to convene those people but give them restricted information, or whether you should go as far as not convening them. The current I pick up is there's a greater focus on convening in the Jersey case law than in some other jurisdictions. And I noted with interest that in Guernsey there was a trust case in a divorce context, AFERBs, a few years ago, where the court held that you didn't need to convene any of the beneficiaries because effectively they had their say in the foreign jurisdiction and the litigation there as to what course they wanted the trust to take. The final point on who disclosure needs to be given to is that if you're an outsider with only a personal claim, as opposed to someone saying that's my property, obviously you're generally outside the net of the principal, and you don't even get limited information or indeed joined. The X and Y case in Cayman from a couple of years ago is a good example of that. If you've just got a personal claim, you don't normally get joined. You take the trust as you find it for the purpose of enforcing your personal claim against it. You're an outsider, not in any way an insider or potential insider to the trust. So I'll hand back to Simon with that to deal with the last situation.
Thanks, Jonathan. So the final practical problem we wanted to consider are those cases in which trustees faced with the obligation of full and frank disclosure, going off to court to get a blessing, are faced with representative beneficiaries, or rather prospective representative beneficiaries, who either can't or don't want to assist with putting the court in the picture for various reasons. Now, this can take one of several forms. First of all, you could have a prospective beneficiary, Ben, who is reluctant to act in a representative capacity because the decision for which blessing is being sought is highly contentious, and that beneficiary might be concerned about his or her role becoming knowledge amongst the beneficial classes. That's one particular problem. A second might be that you have a very small class of membership for a particular class, and those within that class may say, for whatever reason, they're not interested in getting involved, they don't have the time, and so you may be faced with a class that is unrepresented, as it were. And thirdly, you may sometimes have beneficiaries who are willing to act in a representative capacity, but only for a fee. And what should trustees do in those circumstances? So dealing with each in turn, well, it seems to me that the first, where you might have a beneficiary who's reluctant to act because of concern about his or her role becoming public knowledge, that usually can be dealt with fairly straightforwardly by way of confidentiality orders, assuming the concern is a valid one. But usually you certainly in my experience, you can get beneficiaries sufficiently comfortable that the confidentiality regime will ensure that their identity is kept secret if that is indeed a valid concern on the facts of the case. As for the second type of practical issue, where you might have a small class of beneficiaries and nobody really wanting to act, well, again, that can fairly easily be resolved simply in appointing an advocate to act in the role. That is something that in Jersey, obviously, you're very familiar with. In England, it's slightly less common, but I certainly have seen it on one occasion where we didn't have any members from the class who were willing to act, and so the court appointed a solicitor to act in the role. The third case, where you have a potential representative beneficiary who is unwilling to act without a fee, does present slightly more challenge, but it seems to be the answer is reasonably clear. In the ordinary course of events, no emolument should be paid. And why is this? And it seems to me there's three reasons for that. It's a matter of presentation, it's a matter of consistency, and it's a matter of comfort. Dealing with the question of presentation, first of all, trustees are not going to want to be seen to be paying off, if I put it that way, beneficiaries. That is how it might be perceived as being. Now, of course, there is a question as to whether it would be even within the scope of their powers or a proper exercise of those powers in any event. But even assuming that it were, I certainly haven't seen a case where one could argue that. There is this matter of presentation the trustees are going to have to face up to. Secondly, there is a question of consistency. If you had one person and one class being represented by a paid representative beneficiary, well then that sets up a distinction between that class and any other classes of representative beneficiaries who are not being paid, and you have inequality of treatment, and that is going to be a very serious concern both for the court and other beneficiaries. And finally, there is the question of comfort, and I mean comfort from the perspective of the court, because one has to go back and consider what the role of a representative beneficiary is. And that person is there to assist the court in ensuring that all proper arguments are put before it, and ensuring that the full and frank requirement is met. It's a little bit like an amicus curiae brief. Obviously, there's important differences, but essentially the rep ben is performing some sort of a public function, a function outside his or her own personal interest. And in those circumstances, it would certainly look very odd, to put it at its lowest, that person were being paid by the trustees in order to perform that function. And so the practical usual response, certainly in my experience, is if a beneficiary wants to be paid to perform the role, then that beneficiary is not suitable to discharge that function. That is the final practical problem that we wanted to consider. And so with that, I'll hand back to Jonathan.
Thank you, Simon. Well, if you stuck with us this far, you can plainly handle the truth of full and frank disclosure. I'm looking down to see whether there are any questions at all. I see that they're not. So all that remains is to thank you very much for listening, and we hope to see all of you in person as soon as possible. Thank you very much.